Hi, welcome, ladies and gentlemen, and welcome to the Law on the Bosphorus Istanbul International Summer School Program 2020. And now we are on the second day of this program, and the second session will continue with the speech given by Professor Dr. Cüneyt Yüksel. He will give a speech on international law in combating the global crisis caused by COVID-19. So the stage is yours, Professor Yüksel.
Thank you, Mr. Chairman, distinguished professors, students, and ladies and gentlemen. It's a privilege and an honor for me to address this distinguished gathering. I am very pleased to participate as a speaker at the prestigious Istanbul Law School's Law on the Bosphorus International Summer School, among renowned academics from Europe and Turkey. As this is the second time for me to participate this academic program of Law on the Bosphorus International Summer School, discussing the most important and crucial subjects of our time from legal perspectives. I am most grateful to our program organizing committee, particularly Professor Dr. Adem Sözyer and all the other colleagues who made this important program possible. Today, in this section, my topic is also one of the most pressing issues of our time, namely international law in combating the global crisis caused by the COVID-19 pandemic and infectious diseases. Along with the losses of many lives, the pandemic caused maybe one of the most devastating damage in the last century on many fields, such as healthcare, economy, trade, and tourism. Even though handling such a crisis requires intensive cooperation on a global scale, many states have been resorted to more isolation and solely national solutions. Therefore, the trajectory of globalization, as well as concepts such as multilateral international systems and international cooperation, became questionable. And the rapid contagion of the pandemic has inevitably brought into question the roles of international institutions, primarily the World Health Organization, WHO, but also the United Nations, the World Trade Organization, and the European Union, which are expected to build global cooperation and coordination. Let me quickly outline my talk. In this presentation, I will provide an assessment of the institutional mechanisms and instruments in international law for combating the global crisis caused by the COVID-19 pandemic and infectious diseases. First, I will try to explain WHO's structure and regulations, and particularly the international health regulations of 2005 in detail. The main purpose of WHO is to become a global public health authority which could develop international health norms and coordinate international cooperation on health matters. The WHO Constitution clearly states that it aims the highest attainable health level for all people. The establishment of WHO is the clear demonstration of the strong and collective will of the international community in order to improve the level of the global public health after the Second World War. This is why the member states granted significant normative authorities, which most other international organizations do not possess, to WHO. However, it became clear in the 21st century that the IHR, International Health Regulation of WHO, was not addressing the realities on the ground anymore and was insufficient for the struggles against pandemics. A new version of IHR was adopted in 2005. This new version brought about great changes in rules of the international health law, and the system was improved. The SARS, which is severe acute respiratory syndrome pandemic, was the main accelerator of these changes. And now the IHR 2005 regime is subject to a serious scrutiny during the COVID-19 pandemic. In the second part, I will try to evaluate the functionality of the WHO system during the COVID-19 pandemic. Furthermore, I will also propose some solutions for the current deficiencies of the system, such as the insufficient framework for the development of the national public health surveillance capacities, or the lack of a mechanism to enforce the implementation of the rules. However, the combat with the pandemic has also once again proven that current global health governance and implementation of the rules are highly dependent on the behavior of states. Therefore, it is accurate to argue that most of the deficiencies of the current system are directly related to the non-compliance of states with international health regulation norms, even though WHO itself has some shortcomings in general. Finally, I will try to examine the direct relation between the global crisis caused by the COVID-19 pandemic and infectious diseases, and the roles played by global governance system in the fields of international human rights law, international trade law, and international collective security system. I will discuss in the context of international human rights law the matters of the right to health, derogation, the confidentiality of personal information, and surveillance technologies. Furthermore, in the context of international trade law, I will try to focus on the exceptions stipulated by the General Agreement on Tariffs and Trade, GATT, and other WTO agreements regarding trade measures and the matter of intellectual property in medical field. Last but not least, I will also examine in the context of international collective security system, the first and foremost issue is the role of the UN Security Council in combating against pandemics, particularly the Security Council's previous responses to the other pandemics in comparison with its response to COVID-19 pandemic. And in conclusion of my talk, I will emphasize the significance of international law for effective solving global problems such as pandemics. Unfortunately, as you know, many factors, including the tendency of many states to adapt solely national solutions during crisis moments such as pandemics, the rapid politicization of the global health matters in a way to sideline human rights concerns. The lack of capacity of many states to combat the pandemics, the insufficient level of global funds, the ideological disagreements on public health policies, these all restrict the possibility of the creation of a ground for international solidarity and cooperation needed by the international community. The most important core global value which should facilitate the creation of this ground shall be, in my view, international law, because international law having many critical roles to play for the resolution of global problems. And the virus having caused the current pandemic is one of the invisible enemies of humanity. Just like global problems which do not recognize national borders, such as, but not limited to, climate change, transboundary criminal organizations, or terrorism. The main feature of such global problems is that they are irresolvable by any nation state alone, regardless of its national wealth or power. This is why combating global crisis requires the coordination and cooperation of international law, and why international law is our most significant global value system. Now, the COVID-19 pandemic, which emerged in late 2019, continues to unsettle the entire world rapidly. This zoonotic virus, which is estimated to be contaminated to the people from an animal market in Wuhan, China, has caused the death of hundreds of thousands of people around the world. In addition to the casualties, we have been witnessing perhaps the most appalling damage of the last century in many fields, such as health, economy, trade, and travel. Besides, the global trade has experienced a decrease of almost 1/3. A crisis worse than the global economic crisis in 2008 seems inevitable. Arguments that COVID-19 pandemic will go down in history as a crisis which will cause paradigm shifts on a global scale, such as the First and Second World Wars, or the 9/11 attacks are also frequently raised. Many states have taken unprecedented measures and have had to declare a state of emergency. International organizations such as the World Bank and the International Monetary Fund have announced emergency economic aid and support packages. Due to the staggering effect of the COVID-19 pandemic, which brought such a large scale and multifaceted crisis. Even it has been criticized whether or not the age of globalization is over. Indeed, one of the biggest debates of this process is the harsh accusations against China and the World Health Organization, which is the main authority of international health management. The claims that China made the official notification in December 2019 and it did not take necessary measures on time are seen as the main reasons that the rapid spread of the pandemic. On the other hand, the ongoing debates on the mechanisms related to global governance in general and international health law in particular are not limited to China or WHO. Almost the entire international system is being questioned. The rapid spread of the COVID-19 epidemic has brought forward the roles of mechanisms that are expected to ensure effective cooperation and coordination on a global scale. As an example, WHO and WHO regulations have become one of the top topics on the international agenda. Besides the functionality of international organizations, such as the UN, World Trade Organization, and the EU have been started to discuss. Many factors, such as the tendency of many governments to adopt a national approach in such times of crisis, the rapid politicization of global health issues, which can subordinate humanitarian concerns. Many states' lack of necessary resources to combat the epidemic, insufficient funding on a global scale, ideological differences in public health policies, severely limits the possibility of creating a global solidarity ground at the level required by the international community. With the COVID-19 outbreak, an opportunity has arisen to bring up and review the regulations and structures on international health law on a global scale. Very important questions emerged, such as what are the obligations authority sharing and procedures stipulated by international law for transboundary epidemics, whether these have been followed in the current crisis. If not, what is the cause and solution of it, and what is the role of international law through international law institutions, whether the current law and influence of international law should be increased or reduced. Actually, this is the main question of my talk. What kind of role of international law should play in this crisis, whether we should increase or reduce the role of international law. As I said, the purpose of this talk is to evaluate the institutional and mechanisms and regulations regarding global epidemic management in international health law, as well as to examine other important fields of international law. Therefore, it is important to examine WHO World Health Organization, perhaps one of the most important actors of the process, its regulations and its functioning mechanisms. Lawrence Guston, one of the leading figures in international health law, defines this area as the field composed of both binding and non-binding international legal instruments which shape the norms, processes, and institutions to achieve and provide the highest attainable physical and mental health standards for the world population. The right to health is recognized in the Universal Declaration of Human Rights. Also, the International Covenant on Economic, Social, and Cultural Rights, which is one of the most fundamental multilateral conventions on human rights, contains relevant regulations regarding this kind of human rights. Now, you see in the presentation, perhaps in your screen, Universal Declaration of Human Rights, Article 25, and also International Covenant on Economic, Social, and Cultural Rights, Article 12. So one of the most critical areas of international health law is actually combating pandemics. Contagious diseases continue to be one of the global problems that pose the greatest threat to human beings who have struggled with various epidemics throughout history and have suffered great losses many times as they enter the 21st century. COVID-19 affected the whole world in a short time, as you know, after its emergence. And once again, the issue of public health has become a global problem. As the main hub for global public health management and international health law, WHO has naturally been the essential platform for the global fight against an international cooperation with the COVID-19 pandemic. However, the international cooperation on issue of public health is not a new phenomenon that started with WHO. It is accepted that international health cooperation started at the International Health Conference held in Paris in 1851 as a result of a series of conferences that followed this conference. The International Health Convention entered into force in 1892. The purpose of the agreement was to fight the cholera virus. In 1897, for the first time, an international agreement aimed at combating the epidemic was signed, and 1903, all agreements made until that time were brought together in a single international health convention. In 1902, Pan American Health Organization, PAHO, was established. In 1907, Office International Hygiene Publique, OIHP was established as the first international intercontinental cooperation platform. After the First World War, the League of Nations established its own health office. Public health cooperation on the international scale, which was severely harmed with the Second World War, but was revived with the establishment of the UN instead of the League of Nations, which was abolished after the war. In February 1946, the UN Economic and Social Council asked for the UN Secretary General to invite member states to negotiate a platform that will institutionalize international health cooperation. The International Health Conference was held in July of the same year, and the constitution of the World Health Organization was accepted and signed by 51 UN member states and 10 UN member states. WHO has been granted the status of an expert organization of the UN. OIHP and PAHO also have been a part of the WHO. The main purpose of WHO is to become a global public health authority that will ensure the development of health norms at the international level and coordinate international health cooperation. Accordingly, the WHO Constitution has adopted the goal of achieving the highest possible level of health for all peoples. The establishment of WHO shows the existence of a strong and collective will among the international community regarding the development of public health globally in this period after the Second World War. This is actually demonstrated by the broad normative authority given by member states to WHO to fulfill its function, and that is not very presented in many international organizations. Today, WHO is the largest specialized agency of the UN, and the power of the World Health Assembly, which is the main decision-making body of the WHO, to adapt agreements that will be binding for the state parties by a 2/3 majority vote, as well as the fact that some regulations to be made by the WHO and accepted by the simple majority in the WHA, World Health Assembly, are automatically binding for the member states. The international health regulations, which is a product of WHO's normative authority, as I mentioned before, is a very important point that should be especially emphasized in the history of WHO. The International Health Regulations of 2005, which contains new and extremely critical provisions on combating epidemics, is frequently discussed today in the context of COVID-19 outbreak. The main purpose of IHR, which aims to add a comprehensive legal framework to international health cooperation and to expand the basis of cooperation on which WHO is the coordinator, is to prevent and control diseases that spread internationally and threaten public health through proportional methods that will not bring to standstill international travel and trade unnecessarily, and protection from these diseases. In this regard, the notification obligations given to the states are one of the important cornerstones of the IHR. Another very important feature of the IHR of 2005 is that it draws the legal framework of the health measures that the states parties can put into action in cases such as epidemics that constitute a public health emergency at the international level in a very detailed way, and gives WHO the task of coordination at that point. Let me show you in the presentation the most important provisions of IHR, International Health Regulations of 2005, which was made after SARS crisis. Now, IHR Article 4 imposes the obligation of states parties to establish WHO national communication centers in their countries, and states that these centers should always be open. Article 6 of IHR states that each state party shall notify WHO by the most efficient means of communication available by way of the national IHR focal point and within 24 hours of assessment of public health information of all events which may constitute a public health emergency of international concern within its territory in accordance with the decision instrument, as well as any health measures implemented in responses to those events. Article 9 of IHR states that WHO may take into account reports from sources other than notifications or consultations, and shall assess these reports according to established epidemiological principles and communicate information on the event to the state party in whose territory the event is allegedly occurring. Before taking any action based on such reports, WHO shall consult with an attempt to obtain verification from the state party in whose territory the event is allegedly occurring in accordance with the procedures set forth in Article 10. Article 12 states that the Director General shall determine on the basis of the information received, in particular from the state party, within whose territory an event is occurring, whether an event constitutes a public health emergency of international concern in accordance with the criteria and the procedures set out in these regulations. Also, Article 54 states that states, parties, and the Director General shall report to the Health Assembly on the implementation of these regulations, such as decided by the Health Assembly. And finally, I will like to mention Article 56 of IHR, which states that in the event of a dispute between two or more states parties concerning the interpretation or application of these regulations, the states parties concerned shall seek in the first instance to settle the dispute through negotiation or any other peaceful means of their own choice, including good offices, mediation, or conciliation. A failure to reach agreement shall not absolve the parties to the dispute from the responsibility of continuing to seek to resolve it. Now, it is necessary to look at the steps taken by WHO before evaluating what kind of role of it had during the COVID-19 outbreak and how it managed the process. It is known that the first official notification made by China to WHO regarding the COVID-19 virus took place on December 31st, 2019. And also, one of the most critical dates in the process is March 11, 2020. On this date, WHO has revealed its concerns due to the frightening spread of COVID-19, its violence, and the alarming level of the inaction of the states, and declared that COVID-19 has an epidemic status, emphasizing that the emergency response mechanisms should be raised to a higher level. Especially after this point, several states repeatedly introduced strict restrictions and took emergency measures. The COVID-19 Solidarity Fund was established by WHO on March 13, and a clinical solidarity program was launched on March 18 to ensure comprehensive and rapid data sharing. Both steps taken and not taken by WHO in the management of the COVID-19 outbreak are subject to serious criticism. A form of WHO skepticism has reached the highest level, and some states have reacted differently, from threatening to cut funding from WHO to firing WHO officials in their countries. The most concrete criticism directed to WHO about the process is that although China made its first official notification on December 31st, 2019, it took 3 weeks for the emergency committee to convene. Another important criticism related to the first one is that WHO does not have to limit itself only with the notifications from the official authorities of the states when an issue concerning international public health arises related to the scope of the IHR of 2005, and some information can be obtained from non-state actors like private media organs, NGOs, professional associations, etc. Another criticism of WHO's delay in taking the necessary steps because WHO waited until March 11 to announce that COVID-19 was a pandemic. The fact that 114 states have already reported more than 100,000 cases until that date reinforces the criticism that the severity of the situation was not grasped by WHO properly. Another criticism is that the WHO has made statements affirming the steps taken by China, which has been accused by many members of the international community of not performing a good administration and not fulfilling its obligations. And now it seems that WHO has had to take the narrow line between maintaining its intense relations with China functionally and maintaining its moral and legal authority. In response to the criticisms against WHO, it will be fair to take into consideration the following points. WHO, as an international organization, is dependent on the will of its member states to cooperate, no matter how much it is located as main authority of global health management. A functional global management and coordination is almost impossible without the flow of information from the member states. And in this respect, the accusations against WHO may be constrained because WHO does not have an institutional authority to collect data and information by itself in the countries of the member states. If states do not comply with their obligations and do not cooperate, the biggest expectation from WHO may be that it will follow the information coming from non-state actors well. However, a secondary problem with which non-state actors should be taken into account, which is the reliability of the data coming from the non-state actors. One of the lessons to be learned from the COVID-19 pandemic should be that states act following the principles of goodwill in the event of a possible pandemic rather than throwing all blames onto WHO. A multilateral consultation and an action mechanism should be quickly established around a negotiation table. The key point is that states shall put forward a will in this direction and appreciate that the lack of cooperation will be consequences of the pandemic even more grave. Now, one of the suggestions made to ensure the effectiveness of WHO is to move away from the state-centric approach and the organization and to increase the participation opportunities provided by World Health Assembly to civil society and non-state actors in general, in addition to state officials. It may also be among the solution suggestions that WHO should use its current rulemaking normative powers more effectively. There are historical facts that justify WHO's reluctance to use this power more. Some previous steps of WHO, which went beyond technical regulations, caused discussions on political legitimacy of those steps many times, and the WHO's attempts were rapidly politicized. so much so that WHO has made only one general international agreement and 2 regulations until today, despite its rulemaking authority that is not available in many international organizations. However, with the shock of the COVID-19 pandemic on a global scale, the need for the WHO taking more initiative for a more effective global health management is, I believe, emerging. One of the points that WHO is frequently criticized about is that the decisions taken by the emergency committee, which plays an important role in pandemics, are not sufficiently transparent. And the notes of the meetings held by the emergency committee are not published. Instead of such a procedure, it is said that the decisions made should be more detailed, and if any different opinions should be included, at least as opposing views. Another committee that needs attention is the investigation committee. In the current legal framework, even if the reports of the review committee reach definitive findings that WHO bodies or officials are responsible for misusing their positions, those reports are not binding. This situation seriously decreases the control power of the review committee. It also became apparent during the COVID-19 outbreak that the steps taken by WHO and key global governance organizations in other fields primarily affected by the pandemic, such as international trade and transportation, need to be compatible. The best way the best way to overcome possible ruptures would be for WHO to directly consult and collaborate with main global governance bodies of different international legal regimes, like the UN system, the World Trade Organization, and others as well. Finally, I should state that World Health Assembly's decisions to make an independent investigation regarding the steps taken by WHO while managing the COVID-19 process at the meeting held, for example, on May 19, 2020, will provide the opportunity to make a detailed evaluation of the above criticism I mentioned against WHO. If this investigation is conducted comprehensively and objectively, it will be possible to more accurately determine what kind of structural changes WHO needs in international epidemic management. Undoubtedly, international health law and the WHO system are not the only areas where the COVID-19 problem concerns international law. Due to the nature of public health issues that affects many aspects of life, different subfields of international law, each of which with its separate teleology and mechanisms are affected by COVID-19 like epidemics. For this reason, it is important to examine the areas of international human rights law, international trade law, and international collective security, which are the three prominent areas in terms of being frequently on the agenda and directly affected by the current pandemic. For this reason, international health law is not the only area that the international community should focus on. Ensuring the harmonization between the global governance mechanisms in all of those fields with the global health governance should be one of the priority agendas of the international community. In conclusion, the COVID-19 pandemic is not only an institutional health crisis, but a global crisis with economic, political, social, and cultural effects. It emerged in an intensely globalized world where border controls became almost impossible, rapidly spread to all corners of the world, and paralyzed the entire international system. It seems impossible to combat such a pandemic without global cooperation and coordination of all stakeholders affected by the current crisis. As a result, in order to overcome this global crisis, which deeply affects the entire international community, states and other international actors should create a true information and data sharing channels, coordinate their logistics and production capacities, create the necessary financial resources for fragile countries and regions. Ensuring the harmonization of the trade or travel restrictions and respect for the fundamental human rights are of great importance. In our age, effective and efficient combat against pandemics is not possible merely with national steps, but with a solid commitment of states for international cooperation and being bounded by the rule of international law. Instead of an introvert way in which borders are closed, each state tries to take care of itself by its own, and states consolidating their tight control over their citizens, the way of global cooperation and inclusiveness has to be chosen. The COVID-19 crisis has affected every corner of the world, and all of us are on the same ship. Global public health will continue to be one of the most important issues of concern for us in the near future, and no international actor can avoid taking responsibility on this issue. When it is asked whether we need more or less international law in effectively combating global problems such as COVID-19 pandemic, our answer should be the former. And international law should be our most important global value system. Now, I think I completed my time, and I look forward to hearing comments and questions of our discussions in due course. So I thank you, all of you, for listening to me. Thank you.
And thank you, Professor Yüksel. That's a very detailed and fruitful presentation. We learned very much detail from your presentation, especially the legal background and the chronological background of World Health, and also its regulations and instruments, and also the conventions. So we can take questions for the Professor Yüksel.
Thank you, Professor, for your enlightening presentation. I want to ask a question about China's failure to cooperate or inform the international community or health organization, because in a way China hides what's the reality, what's going on in Wuhan, and that's why. Is it possible to deem China as accountable or liable for its failure to inform international community about the emergence of the new coronavirus, as the Article 6 of the International Health Regulation stipulates? Is it possible to sue Chinese government for possible damage other countries have suffered for its failure to inform the international community earlier? Thank you.
Thank you, Ertan, for question. Actually, you're right. China seems failed to cooperate on a timely basis with the WHO, and it became a political issue, as you know, between China and the USA. So, although the IHR Article 6, as I mentioned, states that each state party shall notify WHO by the most efficient means of communication available by way of the national IHR focal point, and within 24 hours of assessment of public health information. Here, we know that the information for COVID-19 goes back to actually November of 2019 instead of late 2019. Like 31st of 2019, China notified WHO, which seems there is a gap between this time from November to end of December 31st. Now, of course, in the world system, when we look at the global governance system, the responsibility of states, you know, how we will bring accountable these countries, for example, if the timely notification was not there. So the system lacks of this issue. Actually, it is a kind of soft part of international law, especially responsibility topic. So, you know, even if we bring China or try to bring China accountable for this lack of communication, there is no efficient way of, you know, bringing China responsible for this act. So that's why it becomes a kind of political issue in global scale. As you know, also WHO's authorities, for example, you know, after China made this notification, they went to China and they even made a statement about how China was successful about dealing with this coronavirus, and the US, for example, was against these statements and criticized WHO statements and authorities, and even pulled its funding and openly, publicly criticized WHO. So yes, I mean, the system, for example, before SARS crisis, before IHR 2005 regulation, was solely depending on states. And after SARS crisis, they wanted to make a substantial change in international health regulation. Then 2005 became 2005 IHR, and there not only states but also NGOs and non-state actors were kind of asked to bring information, or ask WHO to gather information from these resources. But in two ways, as I was talking in my presentation, there are two ways. I mean, once if WHO takes steps further and acts by these regulations, it is being criticized, and if it doesn't take these steps, also it is being criticized. So that's why I say it became a political issue, and also there is more than that. Actually, there is some micro political issues between China and USA, as you know. For example, some funding was made by Gates, for example, to WHO, or Chinese funding was also made to WHO. And there are good relations between China and WHO and Gates Foundation. And Gates Foundation, as you know, Bill Gates and Melinda Gates, owner, did not support Trump in its presidential election in 2016. And that's why Trump always kind of looks cold to WHO, but that's a micro level of kind of global politics. But we know that the US, especially Trump administration, is looking at all international almost organizations in a doubtful way, like NATO and even the UN. So this is kind of like soft kind of lack of international law for bringing this kind of failure into accountable, like China, lack of communication. So it seems very difficult to bring formal kind of way and make accountable China in this sense.
Now, dear Professor, we have two written questions. The first one is, will COVID-19 have a lasting impact on globalization? Will it affect the implementation of international law, as international law is still considered as a soft law? This is the first one. If you want, I can read the second one, or just do you need the one take by one by one?
You can read the other one too.
The second one is, do you see this pandemic as a potential threat to international peace and security, which should be identified as such by the UN Security Council under the 39 UNCH? If so, how effective is such a determination, since the highly political nature of the Security Council, and which role do you see for the Security Council in pandemics?
Okay, actually they are related. These two questions, I think they are related, so I can answer both of them. Now, the biggest question is really, do we need more international law or less international law? Actually, not just in international law, but in every legal question, you know, we ask the same question: do we need more law or less law? Now, for pandemic issue, actually, you know, it came to at the age of globalization, a true globalization. Actually, we see areas like terrorism, like transboundary crimes, organized crimes, or environmental issues, for example. You know, issues on technologies like internet, social media. We see a true globalization. There is not such a way that only one state can deal with these issues or problems. And now it's a dilemma, actually. We live we see it as a dilemma. It is a true product of globalization, which traveled, you know, for example, COVID-19 was seen first in China. It quickly traveled all around the world. By, I think, February of 2020, already we've seen COVID-19 in 114 countries. And this is unimaginable. Before we had this kind of epidemics, you know, like cholera, for example, yellow fever, or others, even MERS and SARS, they were all local. But this time we had a true global virus that traveled very fast. I mean, other viruses can travel also, but you know, this one traveled very fast. In a couple of months, you know, traveled the whole world. So with this kind of problems, you need to have a global governance in place, a true global governance. Because we talk about global governance a lot. We make rules, we make international rules. Some say that international law and international rules are in their still baby stage. They are not, you know, like national systems. And for example, when I mentioned about China question, you know, responsibility issue is the biggest issue and this soft part of international law. But the only way to overcome this problem is to have a real global governance with the rule of international law. I'm not just saying with the rule of law, but you can, I mean, but the rule of international law. When there is a rule, when there is a law, you have to follow, whether you are a small or big country, whether you are rich or poor country. And we've seen actually, no country is exempt from this virus. Whether you are rich or poor, big or small, you are affected. So that's why instead of having introvert or isolation policies, which we've seen, for example, for the first time in the European Union after World War II, we saw borders closed between, for example, France and Germany. That was for the first time. the US closed their borders without even giving notification to EU partners. And the EU partners were in shock. And everybody actually acted that way. It was a panic. It seems that the world was not ready, especially the EU, for example. The EU didn't have any health policies in accordance with, kind of like dealing with this kind of pandemics. Even the world, had historically dealt with similar issues, but still, even, we have WHO, almost the biggest expert international organizations, I believe, along with UNESCO, still couldn't react properly. And there is lack of trust between parties. There's a lack of trust to international organizations. There is a lack of trust to global governance system. So that's why I call it, there is a paradigm shift we have to make in international organizations and even in international law. This paradigm shift, if we are looking for global values, for example, if you make a law in a single country, what holds you together is your value. What makes you a nation, and then what makes you a state, and what makes you, when you have a rule, you have to obey it. So now, I think in international level, also we have enough global values, but these global values should be, I think, based on international law. So we have to give importance to international law, and this international law should bind us all together, whether we are rich country, poor country, small or big country. And if we make such a, for example, if we fail, we have to pay the price and take accountable to failing parties, states, or actors. Now, that's why I say we need more of international law and better system of global governance in order to combat with this kind of problems, especially like pandemics, terrorism, environment, which doesn't care about any borders, like birds or fish. Now, for the peace and security, the role of UN, for example, for that, it was interesting actually. There is a discussion as well, whether we should include UN Security Council in this kind of crisis or not. As you know, the Security Council acts upon if there is a danger in failing peace in the world. There is an example in the UN resolutions and UN Security Council resolutions, for example, for AIDS and Ebola, I believe. For this, the Security Council had a resolution because believed that in Africa, the AIDS and later Ebola would break peace, and that's why acted in a issuing a resolution about this. But with COVID, only, I believe, Secretary General made a statement in the beginning of the crisis that when there's a conflict, or states that are in conflict with others or within should stop, have ceasefires, which wasn't even complied. So it seems that, with this crisis, Security Council didn't act or didn't want to act. And maybe because of Chinese issue, was not able to act because, perhaps any action from US, for example, was going to be blocked because of the veto system by China or the other way around. And many times, we've seen in Security Council this way of behaving. So there is not true, although WHO is the central international organization and part of the UN system, of course, as an expert organization, but still there is a room for reforming WHO global pandemics or other international organizations, like as I said, for terrorism or transboundary organized crimes and so on and so forth.
Dear Professor Yüksel, we have a message from Pınar Hoca, Pınar Ölçer. She sent a message and she explained why. I'm reading it now. Greetings, Professor Yüksel. Thank you for this excellent lecture. Apologize that I'm asking a question by proxy. Leiden Law School prohibits academic staff from participating in the Zoom. So in connection with the question already asked, and in line with your hypothesis that the most important question at this point is whether or not we need more international law. Would you say that the highly fragmented multi-leveled accountability systems which exist in all diverse terrains where COVID has impact, all with different theology, particularly the different courts involved therein, also requires fundamental review? So should there be a more consolidated accountability system with much sharper teeth? We see now the concept of the lawfare emerging, referring to the emergency of highly aggressive litigation on diverse judicial platforms, laying blame with the different actors, including China. All the judicial verdicts to ensue from the matrix of litigation will likely lead to divergent outcomes. Should the paradigm shift you are arguing for mean that we need less different international courts, but rather a more harmonized institutional apparatus where different world courts are charged with own topical domains and their verdicts are not only binding but also strictly enforceable? It was a quite long question. I hope you understood. And so
yeah, it is not a question actually, it's a kind of comment. But yes, we can discuss, whether you have a diverse court system or one central system. Now, we have several systems, of course. You have, for example, International Court of Justice on the one hand, where, states can be party there. You have several arbitration systems, international arbitration systems, for example. But all, even arbitration and International Court of Justice, all of them, you have to have states' acceptance to these venues. So that's the only difference, actually. one state, for example, if China accepts, for example, when there is in IHR also, let me just, for example, in Article 56 of IHR, International Health Regulation, it says, in the event of a dispute between two or more states parties concerning the interpretation or application of these regulations, let's say China and the US, the states parties concerned shall seek in the first instance to settle the dispute through negotiation. So that's classical way, in any dispute, first you can negotiate by the parties between states. Here, China and US, for example. Or any other peaceful means of their own choice, including good offices. Let's say, you choose UN Secretary General as a good offices to settle your dispute between US and China. Or mediation, or conciliation. This is all, IHR Article 56 states. Failure to reach agreement shall not absolve the parties to the dispute from the responsibility of continuing to seek to resolve it. So that's the only way it says, you can choose all these venues: negotiation, good offices, mediation, conciliation, but of their own choice, and you have to agree to it, parties to agree to it. So the question, how to make this system, enforceable, and in many agreements, for example, international agreements, now you have actually dispute resolution solution, but still, if you put a signature to that, for example, in that kind of agreement, you accept the way to solve the dispute resolution, whether in IJC or arbitration or any other venue. So it seems that the world will continue to go in diverse direction. We will create, as international lawyers, to different venues and try to bring cases to different, if we can, to different courts. So it seems, when I look at this issue, it seems that we will have all these different courts working at the same time with different kind of levels. So it will be very difficult to make it a central way at this point. So I don't see in the near future, for example, the centralization of this, dispute solution. So I would say, it will go this diverse direction.
Professor Yüksel, the last speaker will be Merve Çapar. Merve Çapar, I will unmute your mic. You may speak.
Can you hear my voice right now?
Yes.
Okay. First of all, thank you, Professor, for your lecture and shedding light on WHO, especially. As you highlighted in your lecture, transparency surely is one of the most important necessities to combat COVID-19 pandemic. However, without a mechanism, maybe at the international level, which can control the data coming from the states, how can international community rely on WHO statistics, reports, and reviews? because when it comes to risk analysis, data accuracy is very important, I guess. But of course, states can also put forward their sovereignty within their borders when this kind of mechanism is established. I'm really wondering about your thoughts on this, sir. Thank you.
Well, this is, you know, of course, I mean, WHO is being criticized by this, but the way they kind of have their own decisions in different committees, especially, you know, in the committee of this investigation committee, emergency and review committees. Because emergency committees procedures are not, it seems, not transparent, and because of the SARS crisis, the WHO could not act very quickly and on a timely basis. So that's why they gave a stronger position to WHO Secretary General. So, for example, in emergency committee, you know, he chooses the committee members in emergency committees, and it's not included, for example, if there are different opinions, you know, how they reach this committee's opinion for public health concern of international matters, for example. So the outcome, we know the outcome, but we don't know how the process was being made. So that's why, you know, it doesn't look transparent. So it's much better if you put also, you know, with the outcome, this kind of discussion. For example, if there is any conflict among, you know, several committee members, which actually in COVID-19, we know there were. So that's why this emergency committee waited 3 weeks to announce COVID as a pandemic. So it seems for a solution, you know, the process should be more transparent. This is one kind of, you know, solution from my side. And the role of General Secretary General should be discussed, actually. I mean, should we give more power to Secretary General of WHO or less? Should we convey this power to committees or, you know, keep it in Secretary General? I mean, that's actually, we have to, I think it will be discussed in the also near future, because like after SARS experience, there were kind of reform in IHR, as you know, and we had 2005 rules, and now, you know, still almost 15 years passed. So we have to, I think, discuss also reforms in IHR and WHO system, whether we will have, you know, more power for Secretary General of WHO, and also transparency in the committees, especially emergency committees and review committees as well.
Thank you, Professor Yüksel, and thanks for the detailed questions for the Yüksel, Professor Yüksel, and also Professor Yüksel gives very detailed answers for each of the question. As being a moderator, I know we are out of time, but I want to ask one question, if it's possible. As we know from China, after the COVID-19 pandemic, China releases the patent free for medicine HIV virus. So now the Russia declares that they found the COVID vaccines for this epidemic. So can the HY makes pressure or persuade Russia to patent free for this COVID vacancy? Is it possible? Can states makes publicity for this issue? What's your concern on this, opinion on this? Thanks.
Thank you, Mr. Chairman. It's an excellent question. Now, actually, there are some rules on that. For example, in GATT, WTO system, you know, when we have this TRIPS agreement, as you know, if we had in Doha declaration, actually, concerning public health, actually, that this kind of patent would be shared. So, you know, when you look at this Doha declaration, you can see that actually there is an exemption when there is a public concern. There is an exemption to intellectual property rights rules. So there is a mechanism for that, you know, whether it's China, Russia, or US, or Europe, that when there is a public concern, the international property rights exemptions, you know, for within TRIPS agreement and also Doha Declaration concerning public health, with kind of force majeure situations, the state parties, you know, in normal times you have patent protection, but in this kind of public emergencies, you have mechanisms that other countries can produce. For example, if there is any shots, you know, found for this as an exemption. So other countries can use this exemption to produce their own shots. You know, this is a kind of international mechanism that we can follow.
Okay, thanks. I think this is our end of this session. Two important suggestions you made, and I think these are very, very important. One of them is the decisions must be publicized instead of keeping confidential. And the second one is the WHO must cooperate with non-member states and also civil associations. So these are, I think, plays a very important role for the future of WHO. So thanks for this session, and thanks for the Adem Sözer and all the participants and all the lecturers. So
thank you, and I also wish a good sessions, and I hope to see all of the participants next year in face. In Istanbul. Yes, thank you.